This is an English voice translation. It's not like any of the other ones out there that are just subtitles claiming to be English translations. This is a voice translation. It took me hours to do, guys, so please give me a subscribe. I appreciate it very much. And you will see that I'm not the first one to do this. Everyone else after this is just robbing my audio and replacing the video. Let's go.
Mr. the lawyer.
Let Mrs. Angelescu stay.
Thank you for the opportunity of this interview. I'd like to get straight to the point.
Love.
You are to buy into court to defend your clients, the Tate brothers, on the 10th. That's January. So far, up to this point you've had access to the record to formulate your defense.
Dear Mrs. Angelescu, unfortunately not. I would like to point out that the Tate brothers were changed from witnesses to suspects, and from suspects to defendants on the evening of 29 December 2022, the date on which they were witnesses, so they would not have had the opportunity to study the prosecution file. They were detained when the Tate prosecutor brought them to the attention of the accused and issued a detention order, so that on 30 December, at 2 p.m., the date could be set for the hearing of the proposal to issue a preventive arrest warrant for a period of 30 days, and we had the opportunity, as defenders, to study the criminal case file for 45 minutes before the start of the hearing, at which time we also became aware of the content of the proposal for a preventive arrest, which was over 100 pages long.
The first searches took place, as far as I know, in April 2022, when several computers, laptops, equipment, everything that was found there was seized during the search. Well, during that period, while she was a witness, say until the 29th, the 12th of 2022, these goods were returned to them in part.
On the occasion of the search of 11 Apatra 2022, several electronic dividers were seized to be subject to computer searches throughout this period, and we refer in the reference period we have 11, the 4th 2022, 21 of 12 of 2022. Some of these electronic devices have been returned, computer searches have been conducted on them, some have not been returned to date.
It was normal.
From my point of view, the period of time is long enough that they didn't extract the data from all the computer systems, and they didn't do all the computer searches for a period of 8 months.
Man. Now, among the charges that are serious, say quite serious and in the public eye, is the crime of rape. From my information, it would be rape committed against a female person from the Republic of Moldova, and it would be 1 or 2 offenses.
2 material acts are attained.
2 material acts for one of the Tate brothers.
That's right.
Okay, in that context, can you, as their advocate, tell me what evidence there is to support this charge?
Dear Mrs. Angelescu, I will point out from the outset that I have not yet been provided with the prosecution file to ensure the effective defense of our clients. In this regard, I would like to point out that, at least from this point of view, I am somewhat astonished, and together with my colleagues, with the distinguished lawyer Constantin Iangligo and my other colleague who is working on this file, we are sitting day and night to be able to put together the elements of the accusations presented by the prosecutors. There is not a single piece of evidence, apart from the victim's statement, that leads to the idea that a rape crime was committed. Moreover, from the recent conclusion of the Judge of Rights and Freedoms of the Bucharest Court, it is very clear that no such crime is alleged, and that there is no evidence to support this crime, which is why the Judge of Rights and Freedoms has no reasonable suspicion that this crime could be held against any of the defendants.
Now we know very well that the Judge of Rights and Freedoms does not PK the merits as the preliminary chamber judge does. So, in this context, the Judge of Rights and Freedoms focused on the seriousness of the crime, as it is in the letter of the law, to decide this arrest. Moreover, he also weighed up the other 2 offenses of trafficking in human beings and organized criminal group.
Boon, but let me still point out the following issue. Even if the Judge of Rights and Freedoms, at the time of considering the proposal for the issuance of a preventive arrest warrant, is not in the procedural moment to consider the facts, but the provisions of 204 Code of Criminal Procedure in conjunction with 223 Code of Criminal Procedure, do not forget that 223 Code of Criminal Procedure refers to reasonable suspicion. In order for me, as a judge of rights and freedoms, to be able to examine reasonable suspicion, I must examine the grounds described in detail in the report, with the proposal for preventive arrest submitted by the prosecutor, in conjunction with elements from the criminal file that I have before me when I examine the proposal. Or if, after a few hours, the judge of rights and freedoms, having studied the criminal case file in conjunction with the information contained in the report with the proposal for preventive arrest, considers that there are no elements that would give rise to a reasonable suspicion that this offense has been committed, it is clear that the judge himself supports the defense's view. We have no evidence.
Now let's go back a bit to the offense of statutory rape, drawn attention to in the reasoning that was in the excerpt of the reasoning that we released to your thought.
In full, yes.
Integral. It has come to my attention that there are 2 extrajudicial expert reports that have allegedly been made with reference to the 2 female girls, the one who is an American citizen and the one who is from the Republic of Moldova. I would like to ask you specifically about these extrajudicial expert reports. When were they made and when were they made? And if you have any comments on this.
Nice question, and thank you kindly for asking me one, and I'll tell you about his. It was one of our defenses that we tried to use in favor of the defendants, when we were considering the proposal for pre-trial detention. We are talking about 2 extrajudicial evidence reports. What is extrajudicial evidence?
That it was not requested by
prosecutor, that it was not requested by the prosecutor, that the alleged victim, the alleged injured party, is presented to the office of a psychologist. Randomly I choose only according to the criteria of that persons of known applicants and following discussions, analysis by the professional, issued this expert report. I don't even know why we call it an expert report, not even having one.
That's it.
Preliminary. Yes.
Is it really?
That's how I signed this. I call it a psychologist's view of the so-called traumas that people may have suffered. I now analyzed the persons subjected to psychological control by the professional in question. What does it look like to me and what don't I understand? How could the prosecution have relied on extrajudicial evidence, and how could it have presented the court with the proposal for pre-trial detention as evidence on which the proposal is based? This extrajudicial expert opinion, with the quotation marks that are required, these 2 extrajudicial expert opinions, when for 2 such serious and reprehensible offenses, evidence should be presented at the time of the proposal for provisional arrest, that does not raise any doubts as to impartiality or partiality, that does not raise any doubts as to the veracity of the evidence, as to the person who requested it to be granted and administered. So, actually I believe that the injured parties have submitted such a report to the prosecutor, it has been filed in the case file, and it is in great evidence. It has been argued in the case file that the trauma exists, and that the assault, in whatever form it was expressed, is also proven. It doesn't even remotely stand up legally.
I would like to ask you, please, if you can, when exactly these expert reports were taken, when these assessments were made on the 2 girls and if they are still in the country at this time.
I have made it clear from the outset that I will limit myself to presenting in our discussion elements that will not jeopardize the prosecution or in any way impede the proper conduct of the criminal proceedings. However, in the spirit of legality, I reply that we do not know whether or not the 2 are still in the country at this time. But it seems to me that they are still in the country.
I'll go with the source.
From the info on the psychological expertise would have been drawn up around the time of their departure from the country, and you would say today it is an uncertainty. Would it give from the data that they were drawn up after they left the country? But I wonder why these injured persons are not in Romania today. Why the prosecution, in order to respect the fundamental rights of the accused to prove their innocence and to enjoy the presumption of innocence, cannot be heard at this time. We are, Mrs. Angelescu, if someone throws a bomb, a whole Hewlett is created. Everybody is trying to find answers, and the person who threw the bomb, we don't know if he still exists, where he exists, if the accusation is still supported, if the accusation is no longer supported. So, basically, at this moment we know that some people have made some statements or complaints, contrary to the interests of other people. They have gone quietly, and today we don't know where to get them, but probably when we will finally have the prosecution material available to us to ensure an effective defense for our clients, we will also know, as defenders, more data on this subject.
Since they have constituted themselves as injured parties in the case and have claimed damages, or rather harm, as a result of the so-called traumas suffered. This means that the criminal complaints still stand, the preliminary complaints still stand. I am only claiming that you understand that at this moment you do not know when exactly these people left, when the assessment was made, not DNA, and whether they can be heard again, so that you too can ask questions.
Directly in the court at the procedural moment of the trial.
In this thing, data to do by video conference, if only yes.
They could do it electronically. Also, among the evidence requested by us on behalf of our clients, we sent the public prosecutor's office notes of evidence, in which we even requested a confrontation of the injured parties with the clients we represent. For the time being, the case investigator, the prosecutor, has not expressed a position on the proposed evidence.
From your experience, do you think that what we are now calling the Tate case is an investigation motivated by other interests that would be camouflaged? For the time being, let's say, and the investigation would actually be pursuing something else. Do you sense that there would be an extension of the prosecution in the next period that would lead in another direction, which would also be surprising?
I have no intuition at this stage on this subject, as the appropriateness of extending the prosecution to other facts or to other persons belongs exclusively to the prosecutor in the case. However, by corroborating the evidence brought to our attention, through the acts carried out and opposable to the defendants up to this point, with the means of proof described in the report of the prosecution or in the other documents handed to us, the case file does not point out. I don't intuit, but I'm allowed to wonder if there's more to it than that, and we're missing it today.
You probably sense, and we will say, an interference of the Romanian secret services. In this case,
they are. I personally don't see such a hypothesis either. We shall see whether such interference takes place or not. I don't have at this moment, I don't have the file in the country, I don't have the file.
From the latter order, from the reasoning given by the Judge of Rights and Freedoms, does it appear that there would have been an interception warrant or just computer searches?
There have been some warrants. There have been some warrants, but there are prosecutions that we are going to confirm and see how they have been executed and see about their legality. It is too early in the process to talk about that.
And those mandates when the first mandate was given?
When you don't cite years from the file, I don't cite from the file. And I told you, this is data from the file. Let's stick to the issues.
Thinking, interests.
Certain existing evidence at this point.
Yes, it was very interesting why we wanted to make that point. It was interesting to find out whether the first interception warrant was given before the prosecution.
Got it. Yeah, I have a saying next, swallow, give, see.
Okay, I would like to ask you now about this bizarre situation, let's say, in which the Embassy of the United States in Bucharest is at the same time, and how shall we say, the person legal entity that has signaled, has referred the kidnapping and abduction of a person, an American citizen, on the territory of Romania, in the house of the Tate brothers, and at the same time, the embassy is also the one that is obliged to provide consular legal assistance to Andre I, Ted and Tristan too. Have you seen any other cases during your career? Have you ever heard of such a bizarre situation? Yes, it's not a woman.
Yes, I get the question. The situation is not usual. I've never encountered such a situation, of course. But I'm thinking about when the authorities became aware of a possible kidnapping on Romanian territory. When we are talking about a foreign citizen, it is legal. It is only natural that the Romanian authorities should be notified immediately in order to take the necessary legal measures. On the other hand, since other people in the case file are already defendants and are, coincidentally, also Americans, I believe that it was somehow obligatory for the United States Embassy to express its support for the defense of the fundamental rights of its citizens, i.e. to make sure, through this consular support, that they are not treated unequally or discriminated against, because they are American citizens. The situation is unprecedented, but how does an embassy or consulate do its job? No, it's not really our job as lawyers.
Yes, only in this case it's up to the Tate brothers. Whether they agree to be granted this consular assistance or not.
Yes, today yes.
Oh okay, right.
Correct, yes, correct.
So they applied from custody. Yes, yes, this consular assistance, yes, okay, and up to this hour what exactly has this consular assistance consisted of?
To the best of my knowledge, the Tate brothers' wishes regarding the respect of their rights, the faithful translation of every document, of every prosecution document, of every indictment, of every procedural step, have been discussed with the consular representative, and I understand that they have already been assured that they will be provided, or that a competent authorized translation will be provided, so as to make the prosecution and the prosecution documents effective from this point of view, of the respect of the rights of American citizens.
You said they requested a competent certified translation. Am I to understand that there was a translation in court when the DIICOT prosecutor argued for preventive arrest? Not exactly reliable.
Yes, I had to deal with this situation without wanting to without wanting to refer somehow to the professional competence of the lady translator. There was a lot of talk and a lot of information, but the Tate brothers pointed out on several occasions that they did not understand the translation and were looking towards the defense. Frightened, quite questioning. What's going on? What's being talked about? I intervened on 2 occasions, both myself and my colleague Adrian S. Ndulescu, to ask the court to change the translator, as the defendants do not understand faithfully or even generally the charges listed against them. The court stated at that time that all parties in the courtroom spoke English, and that we would be able to provide the defendants with the information strictly necessary to make them aware of the charges for which they were being brought before the court, with a motion for provisional arrest.
As regards the other 2 offenses of trafficking in human beings and organized crime group, what evidence is on file?
None.
Nothing.
In my view, there is no evidence there either, and I am talking about evidence that leads by itself or directly to the formation of an opinion of reasonable suspicion of the commission of acts provided for and punishable by criminal law. In this case, we are talking about trafficking in human beings and an organized criminal group. The documents to which we have so far had access do not accurately describe matters relating to the constituent elements of the offense of organized criminal group. They are not described accurately, the hierarchy of the group is not described, the functions of each person who was part of this alleged criminal group are not described, and also, with regard to trafficking in human beings, as the crime is described, it does not fall within the legal rigors regarding how the crime of trafficking in human beings was committed.
So that everyone understands why when we talk about human trafficking we do not, strictly on the law, have transportation in mind.
Other against the will.
Against the will, a shelter all with by coercion and so on. You say that there is no evidence whatsoever to show from the reasoning of the Judge of Rights and Liberties.
Can I leave our file and I will ask you rhetorically the following question: if in our understanding, from our discussions, you propose to me to come and visit me on the territory of Romania, through you to say me, a Spanish citizen, and I ask you several times, is it sure you want to come, you sure you want to meet us, and you motivate in your decision to come and visit me, namely that you no longer like in Spain, that I travel quite a lot, and I provide you with the financial means for us to see each other. Is there any constraint on my transporting you as a person to Romania?
No, obviously not, but what happens after absolutely matters. Conventions created not by people also involve other types of transport. After I come to say on the territory of Romania, I contact you and then live with you.
Or in the neighborhood.
Or in the neighborhood. Yes, and things happen that traumatize me, because we have here that everyone is very informed on these issues. 6 complaints all.
Not true.
Why do you say it's not true? It isn't.
Not true. That's all I can tell you. There aren't 6 complaints.
There are only 2.
There are not just 2 complaints, but no other complaints either. There are several statements, and from those statements some of them have been deemed to be given by victims, but they are clearly labeled, presented as victims, without them having the status of injured parties in the case, or having ever filed complaints against the clients I represent.
What he said is very important. So there are girls who have given statements, yes, but who have been presented by DIICOT as victims, although they have no prior complaint at this time, and so there would not be 6 prior complaints.
And I stop. I have given general data that the client has given me a mandate to present. I can't talk any more because the prosecution is not public at this time. I am limited to what was described in the Tate communique on the evening of 29/8/12 of 2022 for public opinion, and we discuss around this communique because these are public matters already.
How the brothers feel living in detention. You've seen them.
I see them every day.
You see them every day. So what is their condition?
And, first of all, it took them some time to understand why they were there. I told you the thing about this whole transformation. The turnaround starting December 29. If on April the 11th, 2022, when I'm a witness, there's a house search, all my computer systems in my house are seized. I am cooperating with the criminal investigation authorities. I am making requests for the return of part of my assets, for a speedy resolution of this case, as it may affect my image, and nothing happens. On 29 December, a search is carried out in the same house, and the objects that were the subject of the search in Opal are again taken, some of which are returned.
Ah, so they were the same.
Some of it, but not quite the same, but some of it. But unless I got a cell phone returned, I know. In July, Agua gets me up again. In December, the same phone. Bon. No new facts are noted in the prosecution's case between April 11 and December 29. We are not talking about new facts by the prosecution in the period in question.
It was a question I wanted to ask if it was still taken.
Bribe Weber somehow?
Yes.
No, then obviously these people don't understand anything anymore. What made the prosecuting body decide not to take such a step or not to grant such a procedural quality even on April, and no later than 29 December?
Perhaps because there were no prior complaints.
Maybe, well, let's say, there were no prior complaints or some statements would not have been turned into mirrors. Wouldn't the quality of some statements have changed, the quality of some people into victims? But reading Shed, it's not about new elements, it's not about new elements leading. From my point of view as defenders, it is obvious that the prosecution has a different position. Yes, but from my point of view as a lawyer, I say so if I do not have new elements. On what I go to the proposal of arrest on concrete social danger to public order. On 223, second sentence, paragraph 2, second sentence of the Code of Criminal Procedure. That is to say, I am going on some issues that support my theory that the release of the defendant would be a concrete social danger to public order, would create a disadvantageous image of the execution of justice, of the way justice is carried out. The defendant could evade prosecution and flee, or the Tate brothers. Even if we were dealing at that time, 11 April 2022, with an in rem prosecution, it was obvious that the prosecution was not aimed at him. Clear. And then, if I know in April that there is a case file where they are being prosecuted for an act of rape against me, they have left the territory of Romania at least 6 times, and have returned and have never fled. What would have made it appropriate in December to change the way they cooperate with the criminal investigation authorities?
I understand that in the reasoning there are, however, some transcripts, it says, or certain fragments of discussions that would have taken place between them and the injured persons, so to speak. And there are also some, let's call them statements made by one of my brothers on certain social media channels, in which the Judge of Rights and Freedoms noted that there was a contempt for the law and for women in general. These seem to have weighed quite heavily in convincing the judge to give the arrest warrant. What do they say about this attitude that they had? Are they sorry? Do they have regrets?
No, I'm not saying about a regret, about regrets. I'm not talking about regrets, they're talking about the next issue. On the claim that they have contempt for women, they say that these issues are ripped out of certain contexts, certain interviews that they've been doing on social media for over 2 hours. But they still say if we live our lives surrounded by over 300 people, women and men, we have a lot of friends and supporters around the world. We have been out in public all the time with our girlfriends, and there have been no complaints from our girlfriends. Even public people have come out these days in the public space and said that they were together with Fra, one of the Tate brothers. And it's not about Oimad. This is not about a violent, uneducated, abusive character as he is being portrayed at this time. How could he have made such allegations in cyberspace, on the one hand? On the other hand, Mr. Tate claims that his discussion about Romania being corrupt is absolutely taken out of context. In a discussion, in an interview lasting over 2 hours, in which he talked about the fact that in other countries, there's a high degree of corruption, which is likely to spark international wars, and that in Romania things are much easier, that in Romania he has not seen such corruption, that in Romania he feels safe. And I really understood from him, and we are going to prove it. Of course, we are on working teams, and the working team that is being obtained, that is making sure that we get the data on social media, will provide us with all the necessary information in time for the defense. I understand that, on the contrary, he was giving an example, sir, if I am caught driving at I don't know how many kilometers per hour, it is not such a serious offense. I can make a complaint, a judge can come and see if there is evidence that I committed that offense or not. I understand from them that it is an act taken out of context, and that he has always promoted Romania in a positive way.
Last question.
Forgive me, I'd like to say one more thing I'd like to say, and it's a point supported by my clients, in which I think, made me believe the difference between character and person. We live in a reality of 2023, where various people promote themselves as characters on social media, promoting an image, a product, an idea.
False.
Current.
Saying false.
I don't know if it's necessarily false in integration, that.
They wear a mask just like actors.
Right.
Who actually sell on social media what they want.
I'm selling a product.
Network, he says.
Right. Personally, I sit and wonder and don't know if it can be characterized as a person or is. Can we make the moral profile of a person so much that it stands as evidence in a criminal trial that shows on social media what the person represents in real life? Maybe. A person is making their image, the source of the media, reprehensible, immoral. And could I, as a common citizen, say Domnul, let me see a Serbian love, or I've seen Ionescu boasting on TikTok, or I know on Instagram. I changed my opinion, I made an absolutely bad opinion, and I can have the utmost disappointment with my own conviction that meeting the real person, to see that he is a more than quality person with stable, solid moral principles. Now, in the case of the two brothers, I don't know what their intention was on social media to promote themselves, but the money doesn't have me. And I wonder, can this social media intent give evidence in a criminal prosecution case of criminal character?
We'll see what happens on the 10th.
Right.
I'd like to ask myself one more question, or rather, one very curious question, one of the TEI brothers. Or did they both have international press connections? Were they at some point presenters or a mediator? I know moderators have worked in.
I know that.
International media.
I know that at the time I met the IT brothers, I found out about them that they were vice world champion in kickboxing, and that, as a result of these world sporting distinctions, they would be in demand, and would collaborate with international TV channels on sports commentaries or sports shows. I also have this information.
Which you supported.
But you held it somehow. Somehow I held it in front of the judge because I had to talk about positive image issues of the two brothers. Somehow in opposition to the image described by the prosecution.
When you know them?
About 4 years.
And how did you meet? How many?
Speaker 2, 35:51 right parenthesis I made the acquaintance. They were recommended to me for legal advice in civil matters.
They have family or?
Speaker 2, 36:01 right parenthesis they have children. They had children. They both have children, but they already have. Children have. Yes.
Speaker 1, 36:06, in Romania we have.
I can't say.
How many children do they have?
I don't know.
You don't know, maybe it's 3 or 309.
Their fathers.
2 are not married but have children. I'm ending a me. Thank you very much for the interview and I wish you luck. On the 10th.
10th, good luck, and I wish that no matter what the truth is in this case, we can clarify the truth as it is, and if there is a reprehensible act, it should be proved as such, and if there is not, a solution should be pronounced by a legal and correct solution. As far as my clients are concerned, we are still at the prosecution stage. We do not know whether or not the case will be sent to pre-trial or when the prosecutor will complete the prosecution.
The whole public is waiting to see the outcome of this investigation and, in the end, the truth is very, very important.
That's right, and we are here as lawyers to ensure two things. 1. Ensuring all rights and respect for all procedural and legal rights of the clients we represent, and 2. Getting to the truth.